Hello, and welcome again to Think Like an Attorney, the podcast. I'm your host, Brendan Cody, and we have a few special ideas here today on the podcast, and it's going to revolve basically around my book, which I've authored, Think Like an Attorney, Power Thinking for the Courtroom of Life. We're going to give you some basic highlights regarding this particular book, and not to read the whole book to you, but just to give you my favorite concepts of each chapter. Regarding the podcast itself, if you feel it's something you can do, and if it's not too much trouble, please like, share, and subscribe to our podcast. There are three things I want to cover today. One is why I wrote the book, who I wrote it for, and what the book promises to do for you. First of all, why I wrote this book. I felt as a lawyer practicing for 30 years that it was time to pay it forward, as it were, and to give others the benefit of my experience. I think that this particular book and the ideas contained can instill confidence, formality, and order in our thought processes. This is essentially a book for who, which is the next step. Who it's for is for non-lawyers who have a deep interest in law, lawyering, or support staff for lawyers. So this can be non-attorneys such as college students interested in pre-law and majoring in pre-law. It can also cover, obviously, law students, paralegals, legal secretaries, and support personnel for law firms, as well as for the court system itself, court administration. That's the primary thrust of the book and who it's geared for, but in addition, it is also very practical, useful knowledge for business people and people involved in corporate business as well as your own small businesses. It gives you some really solid tools to use from the standpoint of thinking like an attorney. What does this book promise? This book promises a number of things. It promises to teach you only the best secrets of judges and attorneys that we can all use. Law surrounds us, law permeates us. Why not learn some pointers regarding law and how things actually work in the real world? This book will provide to you group thinking via the jury big brain. It will try to help you to try the other guy's case in your head, to seeing the other side's arguments and arguing even those effectively as far as your total preparation. The book also gives you empowering confidence skills so that no one pushes you around again in the courtroom of life. Self-advocacy skills are also important because if we can self-advocate, advocate for ourselves, then we can advocate for others. We will also give you rules of court decorum that will make you the most serious person in the room. Law is also a foundation for personal growth, and we also give you legal ethical principles for any situation. The last thing we promise is that we have easy-to-remember black letter laws from each chapter. In other words, when we look at the black letter laws, they're at the end of each chapter. What are black letter laws? They're simply laws that we can count on, that they are immutable, time-honored, and they actually work. These laws, these rules, don't have a lot of exceptions. It's something you can bank on and count on. I list out the laws, these black letter laws, at the end of each chapter in bold black font. I suggest that you, as you read the book, and if you're interested in buying it, which it is on Amazon, if you're interested in buying that and look at it and begin reading, look at the end of each chapter first. It's not a mystery novel. It's not a spoiler alert type of situation. It's a situation where you can kind of prime yourself by looking at the black letter laws and then delving into each chapter afterward. So it primes you for the important key points of this particular book in each chapter. The book design is very deliberate. The book design itself is composed of basically an introduction and a conclusion, and these bookend 5 chapters. There are 5 chapters which basically are as follows: law student thinking, rookie lawyer thinking, trial lawyer thinking, veteran lawyer thinking, and then ethical lawyer thinking. These 5 pillars, as they were, are an evolution of thinking. With each phase that a lawyer goes through, they get better over time and over experience. So after we look at this evolution of thought, we want to start off with the least evolved of the thought, and that is going to be basically law student thinking. And again, remember, these are highlights of the book. These is not a complete treatment of the entire book, but basic highlights that I found were most beneficial and, frankly, my favorite points of the book. The first, chapter 1, we'll go right through that. That's law student thinking. In my previous podcast, you may recall that we talked a lot about law students, and that previous podcast were the tips, must-know tips for law students. So I would refer you and direct you back to that particular podcast and take a peek at that, because it primes you for this law school chapter. Some things, though, that I didn't cover in detail in that particular podcast, I'm going to give you some now. Number one is that when we talk about law students and exams, we talk about Iraq. No, this is not the country, not the war-torn area of the Middle East, but IRAC. It is an acronym for use in examinations. On the essay exams themselves, you need to spot the issue, you need to identify the rule, you need to apply the rule, and then you issue a conclusion. So when you're given a story problem in the essay portion of the exam, and most of these essays are exactly that, story problems, which give you fact patterns that you need to analyze and pick out with issue spotting the most important issues, and then the rule that applies to the legal issue. Then you analyze that, and then you take a side at the end with a conclusion. This is a typical format that law professors love, bar examiners love, because it's an orderly, a clear template so they can see right away where you're going and if you understand the thrust of the question. So try to use that particular template when it comes to your analysis of any story problem in an essay. The next thing that I want to cover is that the bar exam itself. And remember, the bar exam is required after you graduate in order to achieve your license. Without the bar exam, without successful passage, you will not get that license. So it's very important that you pass that exam, and hopefully you pass it on the first try. A couple things to help you do that. Number one, to pass on the first try, is to remember that regarding the actual exam itself, there's a model answer. For example, the bar exam is what I'm talking about, and their essays. The multi-state exam is done by computer, and they quickly make short work of your answers, A through F or A through D, regarding the multiple choice, and that is done by computer. The essay questions, however, are graded by hand, and these are graded by lawyers. And each lawyer will be given, in terms of their essay examination process and looking at the exams and grading them, they're given a model answer. This is the perfect answer. There are no perfect answers in life, as we know, but it's darn near close when it comes to the model answer, which has all of the issues, the proper application and analysis, and the proper conclusion. So these lawyers will look at that model answer, and then they will give their particular grade on each exam. In fact, your exam question may be graded by multiple lawyers, not just one, but maybe 2 or 3 or 4. And so it's a very painstaking process that the lawyers are using and the bar examiners are using to ensure proper treatment and fairness regarding your exam. The other thing and last thing about law students that you need to know is technically you're still a law student until you take and successfully complete that bar exam. Yes, maybe you've graduated, but then you move on to a new course, which is the bar examination prep course itself. And there are a number of them out there. And to keep in mind, the one thing, no matter what course you select, is to make sure that you get every practice exam in that you can. What do I mean by this? There are practice exams that are provided by these preparation courses. Do not neglect the practice exams. They are examinations with fact patterns as well as multiple choice questions that put you under battlefield conditions. You can't just casually look at a particular exam question and do a few and then stop and then have some pop or a snack and then come back to it. What you need to do is put yourself in 90-minute situations or 3-hour situations where you're actually prepping yourself under battle conditions. The basic idea is to make sure that you get every possible practice exam that you can and make sure that you practice those exams themselves. Without doing that, without getting our wind, our speed up, our strength up, all the knowledge in the world is not going to help you unless you are under test-taking conditions all of the time. Okay, the next chapter is Chapter 2. Highlights that I like about Chapter 2 is rookie attorney thinking. The first one is the memorandum. It's important, I think, to know how to do a proper memorandum. A memorandum, it can be a memorandum of law or it can be a memorandum of documenting an event. I think memorandums are great for documenting events. What we need to do is know, for example, if there is a deposition, if there is an event or interview with a client, you need to make sure that you keep that event memorialized. And I will tell you why that's important in a second. First of all, regarding the memorandum, you want to make sure that you have the date, the time, the attendance, and the individuals who have attended the event, and basically what is being said in summary form regarding that event. Again, it can be a deposition, it can be a meeting, it can be inside of law practice or outside of law practice, but it's important to document exactly what happens in terms of conversations and in terms of attitudes, voice inflections, attitudes, even emotions, to document those particular things as happening. It's important you cover that memorandum in detail and write down as much as you can and to make sure that you do the memorandum as close to the event as possible. To keep these notes and memorandums is key because it's for the next person that may get your file. The next person may not have any idea of what's happening in the file. You may be long gone from the firm or the company, but this memorializes exactly what happened in regard to your particular file. So with that particular memorandum, it memorializes and captures for posterity the event in question. And you may not be with that firm, you may be gone, but the next lawyer can easily and readily understand what happened on a file by looking at the memorandums or memorandums of law. In addition to that, in the rookie attorney chapter, I came up with kind of 10 self-protection skills for rookie lawyers, and frankly for you too. Crucial skills that a rookie lawyer must develop early on are those of self-protection so they don't get taken advantage of. They have a lack of knowledge, and other lawyers that are opposing them are going to see that. These skills are confidence building and they are empowering. I want to give you a checklist of things to know as a rookie lawyer so you avoid these problems that can arise in your early years of practice. Again, they're transferable, translatable to any situation, lawyer or non-lawyer. The first one is to absorb more information than you give out. Use the age-old proposition of a proportion, really, of 2 ears and 1 mouth. Listen twice as much as you speak. By listening and withholding information, you not only control the flow of information, but you become more of a mystery yourself. An open book is a wonderful thing, but don't be one yourself. Number 2, avoid making guarantees. There are too many variables in life and in business to give guarantees. Don't back yourself in a corner with too many guarantees of an outcome. In addition, number 3, we need to kind of try the other guy's case in your head. This is very helpful when it comes to your opponent as well as the judge or any other decision maker. This is true diversity in thought. It leads you to well-rounded knowledge of all facts, all facets of your case. To know the other side of your case, the opponent's side of you, the other side of that coin, as it were, it gives you a more well-rounded knowledge of the entire issues at hand. So I try to advise young lawyers is to prepare as those around you would. Prepare both sides of the case, in other words. 4, you want to keep your work product and mental impression secret. The law provides lawyers with a protection, and when it comes to attorney mental impressions, secrets, creative thoughts, they do not have to be disclosed to anyone. And unfortunately, if you're not a lawyer, you don't have that protection. So I try to make sure that I tell our non-lawyer friends that regarding your own ideas and secrets and mental impressions, don't be blabbing them around. Make sure that you keep them to yourselves and be very careful how you disclose even parts of that. We also, on number 5, need to distinguish between book smarts and street smarts. Not all theories work in real life. A hybrid of the two is best. 6, for the rookie attorneys, is to trust but verify. This is a quote from President Reagan. Be sure to fact-check the most important controversial information with multiple independent sources. Take no one's word for it. Trust the information given to you initially, but verify it before you draw or act on any final conclusions. Number 7, which I think is really important, is to research the problem on your own first. If you have a new issue, a new problem, and you're just not quite sure how it works, research it on your own. We have the internet, we have law libraries. Before you ask someone else for help, like a colleague, research it yourself so that if you can't find the answer, then you've at least looked at it in detail yourself, then you can go to a colleague. Ask for help as a last resort, not as a first resort. Number 8, engage in regular continuing education in your field. Lawyers are required to do this and have a number of hours every 3 years, which is in the area of 43 hours of in-person seminars and legal education. It's important to keep up with what is happening in your field and to read up on it. Fields of law as well as fields of business are ever changing with the times. You must keep up with that. Number 9 on our list of 10 is to be the first to think the worst. This is the power of negative thinking as far as I'm concerned. It is important to apply smart cynicism in order to anticipate worst case scenario. When it comes to analyzing a problem, privately assume the worst and then reverse engineer or work backwards from there. Given the profit motive in today's world, we cannot assume that everyone has the best intentions. Finally, number 10, lawyers cannot represent the world. This is very important. We can't represent entire social constructs and philosophies. What we have to keep in mind that ethically and legally, we can only represent the one client. Our duty is to the one client. It is not to the world. With the limitations of time and space, we simply cannot be all things to all people. So focus on your own corner of the world and advocate for that with vigor. Okay, moving on to the next chapter, which is trial attorney thinking. The trial attorney thinking is one of my favorites because it involves actual trials and actual courtrooms. The courtroom I like to start off with is an architectural marvel. It's not unlike a church. A church, everybody goes in, they know exactly what their place is, they know how to behave, they know how to sit up straight, they know how to be quiet, and they know where to sit. The courtroom is not really that much different from a church. The courtroom has a number of architectural features. The first thing that we see is the bench, and that is several feet, a couple, 3 feet higher than the rest of the participants in the well of the courtroom. That's where the attorneys' desks are, and tables and chairs. The only attorneys are allowed to be in the well, unless a witness is called and they walk through the well to the witness box. So let's go back to the judge. The judge, his particular seating is usually a big chair on a higher level with a higher desk that keeps him separate and above, showing the authority of the court itself and the final rule. So architecturally and ergonomically, the judge is above everyone else. We also have a separate entrance for the judge. The judge doesn't go through the same doors as everyone else in the back of the courtroom. He comes through his own private door. The jurors are also seated as well on the other side of the witness box, away from the judge and the witness box and the tables, but they have a very bird's eye view of the entire courtroom. They need to have that because they need to see and hear everything that goes on in that courtroom. But they also is a bar, a kind of a wooden panel that separates them from the lawyers who are also in the well. And this makes very clear that the jurors are separate, and they also have their own door to egress and enter the courtroom. Finally, behind the lawyers and their tables is the bar itself, which is a wooden bar. It is a structure that has a gate, and it prevents anyone from entering that are not authorized. It's not locked or anything, but the bar and the wooden door that swings either way allows the witnesses to go to and from the well and to the witness box itself. And then behind that is the gallery. That's where the public, relatives, as well as people interested in the case, the public are allowed to sit and observe what is happening. Finally, you have the witness box, and the witness box is separate and very close to the judge. I think it symbolizes that the witness will be protected by the judge. Lawyers are not allowed to question a witness right on top of them like you see in episodes of Law and Order. They're not allowed to do that in real life. If they're showing the witness something like an exhibit or something along those lines, they can then provide that to them and go over it with them. But then they have to go right back to their table, which is far away from the witness. There's no browbeating of witnesses in the courtroom. So that kind of covers, I think, a lot of a couple of my favorite things regarding trial lawyer thinking. Of course, the last thing we have to keep in mind is that lawyers, as they prepare their case, can present their case as well and are basically limited and heavily restricted on what they can present and how they can present evidence, which is constrained by the rules of evidence. Evidentiary rules such as hearsay, such as relevancy, such as badgering the witness. Things along these lines are good things to restrict the flow of evidence because we don't have all day and all night to present a case. It keeps the flow of relevant evidence flowing through the court by having these particular rules. In addition, it's important to remember that when it comes to evidence and it comes to trials, lawyers deal in facts, in the presentation of facts, in the reconstruction of events, and this is kind of a cold, hard analysis of what has happened in a case, and we try to avoid emotions and feelings and drama being involved. I think in too many times we see in court cases there's too much drama and not enough facts. Remember, as Laura Schlesinger said, your feelings aren't facts. Another quote, I think, to reverse that is that the facts do not care about your feelings. Facts are something we can look at and see that are objective and reproducible that everyone can see. Feelings are a little bit of a problem in that regard, so we try to keep those out and analyze things properly. That covers trial lawyer thinking. The next thing I'd like to cover is veteran attorney thinking. The veteran attorney has now evolved beyond law students. Being a law student has now evolved beyond rookies, attorneys, and trial attorneys. Through years of experience, the veteran attorney has now learned how to engage in solid, good verbal communications as well as nonverbal communications. Covering the verbal communications, lawyers are very precise on what they say and how they say it. They are wordsmiths in many ways. Precision in diction, in saying exactly what they mean, is crucial to success as a trial lawyer and communicating their part of the case to any jury and to any judge. But many times, even before the trials themselves, there are depositions, and witnesses will be examined by the lawyer, and the lawyer can then delve into nonverbal communications. And nonverbal communications are what the lawyer sees and hears and observes in terms of the witness's body language. This occurs in trials as well. It can indicate deception. If a witness is perhaps blinking repeatedly as they answer a question, or doing this with their neck and soothing type of actions, or clearing their throat, these things might be indications of deception, and what they do in terms of their body language may conflict with the actual answer itself. So a lawyer is always very, very acute. They have an antenna regarding deception and whether a witness is being untruthful by using those body language type of skills. The next thing that I want to talk about is with the veteran attorney thinking is the 4 C's of advocacy. Advocacy is very, very important. And what I tend to do is I use the example of in the past I've had clients that have been charged criminally, and you have to visit them in jail, and you visit them with a plexiglass partition that separates you from the client, with a handset, with phones. And when you walk in there, you really see what the client has gone through. Now, they're charged criminally, and they may deserve to be in jail, or they may not deserve to be in jail. But the point is that client needs a lawyer. That client feels that they have been abandoned, and they're not sure if they're ever going to get out of that jail. And that partition definitely separates the lawyer from the client. So if that occurs, I try to make sure that the client is aware of 4 things. One is that I comfort them. That you give them a quantum of solace, a measure of comfort, to let them know that they are not going to be alone, that they're going to have someone with them. That also delves into constancy, that the lawyer is never going to leave their side. Once they retain me as their lawyer, I'm not going to leave their side, and I'm going to advocate for their interests and only their interests, which in this case may be against the great power of the state that has the ability to convict and imprison an individual. We also give counsel. Counsel is good, solid, sound legal advice, unvarnished legal advice. And finally, confidentiality. The lawyer is the keeper of client secrets. No lawyer is going to tell anyone what a client tells him. It is sacrosanct, it is confidential, and that, I think, gives a great measure of comfort to the client themselves. So the last particular chapter that we have is the ethical attorney. The ethical attorney, it requires really that we go over and above in terms of our own personal and professional integrity. There are a lot of rules regulating the lawyers, and if they run afoul of those rules, a client can report them to the ethics board, and the ethics board can, in fact, reprimand or suspend, or even, if it's serious, to disbar a lawyer. So lawyers are heavily regulated when it comes to their own conduct, and they're recognized as being professionals and are held to such a very high standard. A lawyer owes personal dignity, integrity, and independence to the administration of justice. A lawyer's conduct should be characterized at all times by a personal courtesy and professional integrity in the fullest sense of those terms. In many ways, we look at the ethical rules, and it's mainly a series of don'ts. You cannot represent a client with a conflict of interest. You must maintain integrity in all things. You cannot steal from a client. You cannot use a client's information for other purposes. These are a series of don'ts. These are a series of negative reinforcements, not unlike the 10 Commandments. Thou shalt nots is the order of the day. And you have to keep that in mind when it comes to lawyers and only demonstrating the finest of conduct at all times. And honesty is a big one. They can't be dishonest, and lawyers get a bad rap for bending rules but not breaking them. But you can't cross the boundary of dishonesty or representing something that's not truthful or remaining silent when something should be brought to the courts of attention. So very strict rules. The final rule about ethics is that we as lawyers have a duty to report the unethical conduct of a colleague. It's called the duty to rat on your friends doctrine, and that is required as well in terms of maintaining the full integrity of the field. Those cover the 5 chapters. I'd like to conclude with just a brief read from the book itself. And it comes in regard to the conclusion of the book, and it's a bit of a very, very poignant story regarding advocacy, and it involves my father. My father was a personal injury attorney, and he represented a lot of people in the neighborhood in their personal injuries, such as workers' compensation, such as motor vehicle crashes, and any other type of injury type of negligence type of cases. So he would represent them against large insurance companies, kind of a David versus Goliath type of situation. So given the fact my dad was a lawyer back in the 1960s and 70s and 80s, he was known as the neighborhood lawyers. Many of our neighbors would call him at home, and he would represent the neighbors in whatever legal matters that they had. He was a real go-to guy for the neighbors. One particular neighbor was Bob Moore. Bob Moore was involved in a case with my father, and his daughter was also involved in an injury case, and he referred Dan, my father, to his daughter as well. So there was a long relationship he had with his neighbor, Bob Moore. Bob Moore developed cancer many years ago and ended up dying of the disease. And we went to his funeral, and we spoke with his widow, Mrs. Moore, and Mrs. Moore told us a story. And I read from this directly. My father and I attended his funeral. His widow approached us and told us a story about Bob's final weeks in hospice care at home. One day she found Bob sitting in his chair, tightly gripping something in his bony fist. She asked him what it was, but he refused to tell her. After some discussion and persuasion, he reluctantly opened his fist to reveal a scrap of paper. He gave it to his wife, and she read her husband's shaky handwriting. The note read simply, Dan Cody. Now, Mrs. Moore told us she reminded her husband that Dan had not represented the family for years, if not decades. Bob replied simply, I'm in trouble, and I need my lawyer. Maybe Dan can help me one more time. What a wonderful tribute to the attorney-client relationship. It's a simple story, but a powerful one. It demonstrates what a legal mind can do, as well as the sheer impact that advocacy can have on another human being. That's my speech. I want to thank you again for listening, and we'll see you next time, and until then, see you in court.